Okay, so I think we are live. Let's see. Okay, podemos começar. She says that we can start. Okay, let's wait just, I don't know, just a few minutes, a few moments so people can join, because Beatriz, nós estamos live?
Sim, estamos. Podemos começar.
Tá bom, então tá bom, a gente espera, a gente vai ver as pessoas entrando ou não, né? A gente não vê, então...
Não, pode começar.
So let's start. We're gonna switch to English so everybody can understand. We understand Spanish. I know María Inés understands Portuguese, but as we agreed, the program will be in English of this meeting. So thank you very much for being here, María Inés, Tatiana, and Ana. Ana and I, I'm the president, and Ana is the vice president of the Arbitration Commission of IASP. And normally we have meetings only for members, but this time we decided to open the meeting for people who are not members, and even inviting people to join IASP, which is a great institution, and we have nice debates about arbitration and other topics. And today we're going to talk about the peculiarities of arbitration proceedings involving the public administration. And we have the honor of having here María Inés Corrá. María Inés has more than 20 years experience in international arbitration practice, both in investment and commercial complex matters. She's president of Latin American Arbitration Association, ALArb, which I'm glad to be part of the board also. President of the Arbitration Commission of ICSID Argentina, co-chair of the Latin America Arbitration Group of the IBA Arbitration Committee, and co-founder and one of the leaders of Women Way in Arbitration LatAm, among other roles of leadership. She's the chair professor of arbitration and mediation at School of Law of the Universidad Torcuato de Tella, and professor of administrative law and regulatory law at the Universidad de Buenos Aires and Universidad Católica, Argentina. She's the author of more than 30 articles and papers of her fields of law. Also, we have the pleasure of having here Tatiana Mesquita Nunes. Tatiana holds a master's degree in state law and Bachelor of Law degree from University of São Paulo Law School. She holds a master's degree in social security management from Salamanca University. State's attorney, and she's a state's attorney since 2018, and she's deputy coordinator of the State's Attorney Arbitration Specialized Unit. Thank you very much, you both, for being here. The topic that we're going to discuss today is always a hot topic in international and in domestic arbitration, and the numbers of the AGU shows us that arbitration is really being used by the public administration in Brazil, and María Inés will share her experience in international arbitration and in Argentina. But just to let you know, for instance, the numbers of AGU shows us that in 2023, the public administration signed 216 agreements with arbitration clauses, and that there were 104 arbitration proceedings involving the public administration. And a very impressive number that maybe Tatiana can comment with us afterwards, that the arbitration handled by AGU have resulted in gains of 184 billion to Brazil. So the numbers speak for themselves. Public administration is really using arbitration. So we would like to take this opportunity to understand and to debate how are these peculiarities, which issues we should take care of. Anna, we were discussing beforehand here, and she was telling us that whenever we have the public administration, we have double attention to the case, which is normal because it's public and you know, it involves, you know, many interests. So we agreed here that we're going to have a debate. So I'm going to pose a few questions, and María Inés and Tatiana, they can feel free to comment, to answer, and to pose other questions. And in the end, we're going to open for the floor, so if they have any questions. So my first question is, why arbitrate with public administration? I don't know who would like to start. Maybe, I don't know, Tatiana, who is part of the why to arbitrate.
Okay, first of all, I would like to thank you, Eleonora, Ana, for the invitation to be here with you. It's also an honor to be here with María Inés. She has quite a CV, and it's really an honor to be here with you. I'm a learner of arbitration. As you said, I have been working with that since 2018, so I'm young at that. As public administration is the young at arbitration, I believe. And for that, with that, I can answer your first question, Leonora, because I can speak a little bit about the view from inside public administration. As you said, I am a state attorney who works with that for federal union here in Brazil. So there is like things that people say and things that I saw as why arbitrate with public administration. People say that arbitration's clause give security to investors, especially international ones, because they see a procedure that is similar to others in other countries. As Brazil has its law, very similar or modeled by UNCITRAL, we have like a model that people are used to use abroad. So they feel very safe to have it, and maybe this could be a reason. Therefore, there isn't much study about that. Profound research that say that can state, oh, the investor, they want to invest in Brazil because public administration use arbitration procedures, arbitration clause. But it's something that people often say. When we are inside, one of the things we know, the people who work in public administration want is to have security. And how they can have security? We can think about a contract, a long-term contract, as the ones that normally have arbitration clause. So there are contracts with 30 years, 40 years, 50 years maybe, so are long-term contracts. And we can think about it as a marriage. When people are married, it's very, very bad for the relationship to be fighting during the marriage. It's not good. You have to have a breakfast with that person. You have to be with him or her all the time. It's the same for the contracts. If we are in a conflict, it's not good for the relationship that is in long term. It's not good to have a conflict for a long time. So the use of arbitration, I think the first thing that we want when we put an arbitration clause in a contract, a long term, that's normally the usage, is to have a quick response for a conflict. So I want to fast enough deal with that and have my relationship good again with that person, that private party. So I think this is very, very important. And also, public administration is very technical. We are bound by law. We can't we don't have so much space to decide. So the fact that we will have a technical decision, we can have arbitrators that are specialists in that field, that we feel safe about their decision. I think that is also good because, as I said, the relationship goes on. So if they have a decision that's good for the contract, it can be replied after that and maybe it can avoid new conflicts on the same issue. So I believe these are the two factors why public administration use arbitration clause. And all of it also has this other factor, but I think this other factor, the one that investors like, is something more difficult to have certain of. The other two sides, I can say from inside, there are things people look for when they are choosing arbitration instead of a judiciary system.
Thank you very much, Tatiana. Very interesting, the standpoint, the public administration standpoint. María Inés, would you like to comment from a different standpoint?
Yes, well, they're different. It's another concurring, if you want, standpoint, maybe from the private parties interested in entering into contract with the state, and they are interested because the state is in Latin American country usually the main consumer in their own market. Maybe we need to think of course, neutrality. In international transactions, neutrality is a matter, is an issue. It's not something additional, it's not a myth, it's something actual, important, and with impact. And it's natural to have some distrust on the state courts when the conflict is with the very state and not someone another private party. And I can say here that even in an international transaction, even when the transaction of the relationship is between private parties, one party may have some doubts on submitting the dispute to the courts of the other party. Well, this is even more evident when the counterparty is the state, because it's submitting the dispute to the state courts, the same state courts. So neutrality is important, and of course, one of the most important things in international transactions or international investments, if you want. But it's not only that. Of course, I second and back what Tatiana said about the length and duration and usual duration of court proceedings, plus cost for the relationship, because in any contract with a public the public party, and in a public contract is really difficult and something bad for the parties and for the contract and the relationship, and ultimately for the public interest involved in that relationship and contract, having both parties fighting every time before courts, and with proceedings that will last. And we know that those proceedings last more than any private dispute. So neutrality, cost and length, and also fairness, because the private party and mostly foreign investors in a country, in a host country, have that genuine interest to avoid unfair treatment, even by domestic courts. So, and we know that when we are dealing with disputes arising from public contracts, public procurement contracts, which is another thing in comparison with commercial contracts by a state-owned company. In those matters, the fairness of an equal treatment by the same courts could be at stake. And here I would like to be caution, of course. This is something that usually happens, because what disbalance or unbalance the proceeding is the invocation of the public interest. But it's a whole issue for the administrative law, and that those are relationships under administrative law. It's a whole issue to discuss the need to maintain or keep the balance in a court, even a court proceeding, without pressure of the presence of the general and public interest, okay? Because you have an unbalanced relationship in any way with the other party, which is the state, and the state exercising its own public powers. So you need to find a forum, and let me say, as an administrative lawyer, either a court or arbitral tribunal that provides both party and the private party an impartial forum and an impartial decision, because you have the imbalance in all your relationship. So that is the place to have the fairness and to have the neutrality, and to have, in any case, either at court proceedings or arbitral proceedings, the fairness or the fair and equal treatment. And foreign investor and private parties, generally speaking, find out that an arbitral tribunal may be more suitable for giving or to give that equal treatment.
It's very interesting, María Inés, your perspective as professor and practitioner in this field. And something that I have been saying for a long time, that one of the advantages of arbitration is that it seeks the material truth. And nowadays, I think the public administration has a more modern concept of, dealing with justice. In the past, they would they were oriented, just to win. I mean, no matter what. And nowadays, I think the principles of proportionality, reasonability, they are much more in use. And because of that also, and because of fairness, equal treatment, and all these values that are very important in arbitration and they're very taken care of, this is one of the reasons why also public administration is using arbitration much more than in the past, I would say. I think it's more modern way of dealing with the, justice. I mean, well, very good. So we have already a few questions, but I think we can address them in the end. But people, you can keep on posting. Anna is helping me. She's also there in YouTube and writing down the questions. But we're going to move on here to the second question. And in the end, we can address all the questions that were formulated by the audience, okay? So my second question is, how is arbitration with public administration different from general commercial arbitration? I know that Tatiana has only participated in arbitrations with the public administration. So maybe María Inés can start answering this one. And I don't know, Tatiana, of course, she knows the you know, the concepts at least, but I'd like to listen from María Inés first about that.
Okay. Well, in arbitration involving public administration, you may find that either legally or factually issues arise, sometimes more often than in commercial arbitration, mere or pure commercial arbitration between private parties. Particularly, you may find that the state often invokes the existence of public interest or legal provisions limiting their power to either to submit to arbitration, even though you have an arbitral agreement in front of you, and also that they have that they have legal limitations that justify their actions or the action at stake. So that is something usual, and you can find that more than in a mere commercial arbitration. Prerogative inherent to the public powers also can be presented or invoked by the party, the state party, and have an impact on, could have impact on the resolution of the dispute. Issues regarding subjective and objective arbitrability, that's something that can appear. Allegation on the other party, on the other hand, allegation of abuse or possible abuse of powers by the state prior to the arbitration or during the dispute or during the arbitration. That are allegations. I am not here saying that though that abuse of power exists or not, but allegation of abuse of power may appear or may be invoked during the proceeding. The state, from a more practical standpoint, the state may require more time and longer deadlines in order to submit their memorials and writs, and this is something that is understandable because there is a bureaucracy behind the state and the state attorneys, and sometimes several steps or approvals that may should be got and obtained, not to submit each of any memorial, of course, but the bureaucracy behind the state is something that is real and actual, and we can't deny that. And the state, of course, may require more publicity because transparency and publicity is a principle, a general principle for state acts, and well, it's the state participation in arbitration may require that publicity or a request or demand for more publicity, and this is a matter. Of course, we can address that matter later, but an apparent, and let me say apparent, conflict between transparency or publicity and confidentiality can appear in this kind of arbitration, and it's important to deal with that apparent tension between both requirements in a reasonable and, let me say, a smart way. Tatiana.
Thanks, María Inés. You gave like this ample analysis, but I have some things I would like to address also, and very good explanation. I think that the point of views are not so different. We share some point of views, even we are in different positions, so it's very interesting to see. You said about the limits we have in the laws. This is an issue when we are talking about public administration, and not just in arbitration, but at all. We have to respect the strict legality principles. So we just can do what the law permits, and the private parts, they can do everything that law does not forbid. And so it's quite different. That's why we had in Brazil a lot of discussion regarding the possibility of public administration use arbitration. And this was just solved in 2015. And that's why when we are seeing the different developments of arbitration in public administration, they are after that, most of them. So our office or general attorney office, for example, we just have a unit for arbitration before this modification. Our unit is from 2018. So you see, we have 2015, like the moment when we were safe about using arbitration. Then we had the clauses inserted in the contracts, and the first conflicts were there, 2018, 2019. We had a lot of specific laws that permitted arbitration in specific sectors, like petrol. We had like an infrastructure sector also. This word is so difficult to speak in English. We had, but for most of the contracts we have in public administration was just after 2015. And then the discussion about subjective arbitrability, it was reduced a lot, I believe. Before that, I agree with María Inés, we had a lot. But after that, I think it's very reduced. So it's just in one or another scenario that we have this kind of discussion. I think when we are talking about Brazilian law and domestic arbitration, the main difference between public administration and general commercial arbitration is the publicity, I believe. It's something that's stated there in the law. So the procedures must be public, and we have like, I know we are going to address this more after, but I think there is two important consequences of that may make arbitration with public administration peculiar inside the whole arbitration system. The first one is that when we are talking about this kind of arbitration, because they are public, we can think about precedents in arbitration, something that was not something to think of before. So we begin to have decisions that we can, maybe when we are addressing the court, the arbitration court, we can say, oh, there was a decision in a case like mine, it was like that. So we start to have this, and also I believe there is more scrutiny over the arbitrators because their decisions are public. So everything, not just the decision itself, the merits of the decision, but also the revelation, also the way they conduct the procedure, everything is over nowadays with public administration, is over ample scrutiny. And this is something, and I believe this is something really important. And I believe also that when we had the publicity for public administration, one thing that I think is very good is that some chambers have changed their regulations to have more publicity also for the commercial arbitrations here in Brazil. So it's something that is a good factor after the interest of public administration in arbitration belief. Other things that is a peculiarity here in Brazil is that arbitrations with public administration cannot be decided by equity, just by law. And there is a huge discussion with by law means just Brazilian law, or if it's possible to use international or foreign law. I personally think that as the law didn't say it couldn't, it can. But there is a lot of discussion about it. And there is some regulations that are below the law, like Decreto 10,025, the one for federal union and agencies in the sector of infrastructure. And this one says that just Brazilian law could be used. So there are some regulations about it. And just to end my line here, María Inés touched 2 points I'd like to address a little bit. The first one was about prerogatives, that María Inés said that sometimes public administration try to use this kind of prerogatives inside arbitration. We here in Brazil, we have some prerogatives under the judiciary system, and we have by law, but we don't have it on arbitration procedures. So when we go to the arbitration, we have some peculiarities, of course, but we don't have the same prerogatives we have on state courts. And the other thing I think it's important to address is the difficulty we have when we are talking about the rights we can dispose. Our law says, not just for public administration, but for all, that the rights that can go to arbitration are the ones that one can dispose. And this is very difficult. This is a very difficult thing to deal with, because we can say what is white, what is black, but there is a gray zone here, very difficult to arrange. And this, I think, is one of the things that lets arbitration procedures more difficult. And sometimes people spend a lot of time discussing objective arbitrability because of that, because there is no concept in law or in regulation, or there are, but they are not enough, I believe, to help us to be secure if the rights we have a conflict with, they are or not rights which we can dispose of. And when we are talking about public administration, I think the issue is harder, because we have a lot of control, external controls, that are looking if we are doing things right. So sometimes we are afraid, oh, we are dealing with something that we are not so sure we can dispose. And there is someone here who is just looking if I'm doing things right. So I have to be extra careful. And sometimes it's difficult to be a public lawyer in this kind of position, because you want things to be made in the best way possible. You want things to be fast enough, but sometimes you have to discuss some things because you don't really know what other external agents will think about the way you are doing things. So this is, I think this is something very difficult to deal with.
Yeah, I agree with that. Let me say something here, because I'm glad to hear that in Brazil this arbitration with the state in public contracts, or dealing with public contracts, set aside, if you want, or are not impacted by the prerogatives, the public prerogatives. But that, because that is a very important difference in that case with the court proceedings, and is another very good reason to the question, why arbitrate with with public administration.
Yeah, very interesting. And that was something I was going to comment because, for instance, even if the public attorneys, they do not have this prerogative, for instance, of having a larger deadline, they don't ask. I mean, they're so well prepared. I mean, they could have asked, they could be asking it during the arbitral proceedings, but I have never seen in any proceedings that I have participated with public administration in which a public attorney has requested longer deadlines or any kind of prerogatives, because they could, they could say, explain to the parties their problems, and they don't. They are really well prepared, and they act as a private attorney, I can say, and in many cases, much more prepared than the private attorneys nowadays in Brazil. I can testify that. One only prerogative that I see still being used by public administration here in Brazil is the advancement of costs. I mean, sometimes in a few cases, for instance, for a very expensive engineer proof involving engineerings and experts, so on and so forth, the private party agrees to advance the costs of this. I don't know your experience with that, Tatiana and María Inés. I think it's the only. You want to comment?
I want to comment about this because I was going to say something about this actually in my bullet points. It was there because I don't believe it's like a prerogative. It's something that's linked to the way public administration works. We were talking before, I think María Inés talked about it, bureaucracy. We have a lot. And if we have the costs of arbitration are something very difficult to deal with inside the public budget, because we have to anticipate in the public budget all the things we are going to pay. And when you have this kind of cost that you don't know when and how much you are going to pay, it's very difficult to do when you have all the limits from the law that you have to comply with. So I believe this is difficult, and as most of the time we are not the claimant part but the respondent, we kind of use that to say, well, the private part, if we don't anticipate the costs, the private part will have to do so. They can go on with the arbitration procedure. Most of the regulations say that. So we try to be very transparent about the difficulties we will have, and before having problems during the procedure, try to have an agreement for the private part to anticipate. And if we lose in the end, of course, we are going to pay everything back. But it's easier because there you have something that's just one time, and then you can manage all the budget issues, the budget law issues before paying the whole amount. It's and normally it's together with the principal amount, so it's easier to deal with that.
Okay, so I think we have talked a lot about the balance between transparency and confidentiality was my next question, but so maybe we can jump to the other question. So which aspects should arbitrators be aware of and attentive to an arbitration involving public administration? María Inés?
Well, I'm not, my comments will not deal with Brazilian experience or particularly Tatiana's experience on behalf of the state. This is a more broad approach, if you want, and taking into account different countries and possible contingencies. And first, subjective arbitrability is still a matter at least in other countries or other states. because in those states where you don't have a well modern and transparent, or at least more than transparent, a good legislation allowing the state or empowering the state to submit to arbitrate, and stating clearly on which matters the state are allowed to arbitrate or submit to arbitration, and which matters are explicitly excluded from arbitration. Well, in those legislation, or in those countries where the legislation is not so clear, it's not so good or not good, but even when you don't have a legislation, but the constitutional rules are not so clear, also, when you can have there some room for challenges, and for challenges posed by the same state or state entity that submitted actually the dispute to arbitration. Sometimes it's not a matter to be allowed or not, but the discussion is about the matters that are submitted or actually submitted, if those matters are arbitrable or not for that state. That is the objective, the objective arbitrability. But in or taking into account the state sometimes states mix both discussions and say, well, I am empowered to submit this kind of matters, but not these other matters. So you have both things involved in the same discussion. For the same principle that Tatiana mentioned before, which is the very well-known legality principle that governed the whole actions and life of the state. But having said that, and I can also include, but these are things that the arbitrators and parties should be or must be aware of and attentive. Apart from the legal allowance or the constitutional allowance to submit to arbitration, you may add formal requirements for the approval for that submission, or the approval that some entity must give to submit to arbitration and formalize or execute the arbitration agreement. So you can have the legal allowance plus certain formalities or formal requirements that the state must comply with. And all of this is part of the same ball of issues, of potential issues that may arise when the arbitration actually is pursued and is initiated by the counter or the opposing party. I think that this is still an issue when the state are in front of the dispute and don't want to or must or are respondent. Well, they use all the tools they have in order to resist the proceedings, and I think that this is not also an issue, but you need to resolve that issue as an arbitrator, of course, and in front of the legality principle and all these principles, you need to take into account also another principles. For instance, the good faith principles. And let me say here that there is a trend, and I'm not here sharing my own thoughts in particular, but the trend. There is a trend in arbitration and international arbitration that said, well, wait a minute, we need to pay attention also to the good faith principle, because when the state executes an arbitral agreement, provide the other party a legitimate confidence and trust on a very essential fact, that is that that entity, state entity, will comply with that that commitment that was voluntarily undertaken. So you have there some different principles, all of them relevant principles in terms of allowing good relationship and good transactions and future good transactions for the same state, because trust and confidence is important. I am not talking here also to only to the importance to preserve and respect legitimate confidence are expectations. We know all of us know about that, but it's important to maintain the balance. And it's important not to allow a party, even the state party, to simply say, well, you know, I was not really empowered to do that. What a pity. Go to my courts and see if you have any right on this dispute. It's not just simple, you know? So I don't believe, and I don't have that bias that the state is always wanting to act in bad faith. No, not at all. But sometimes parties, and also state parties, extreme the interpretations, extreme the way to construct the contract, even the law, even the case law, in order to avoid what we all of us want to avoid, which is the dispute and the conflict and eventually the need to respond towards our or the other party, or the private, in this case, the private parties. So it's important to be here, to be to state, the state should act in good faith in all their matters. You know that, all of us know that. And that includes to admit the arbitration clause when the arbitration clause was executed and has the appearance of a legal agreement or arbitral agreement, and resist eventually the claim with all the tools that are in good faith available for that state. And the same applies with the private parties, okay? Because this is a fair play, and the state must be ruled by the first play also. Sorry.
Before no, very interesting. Before I pass the word to Tatiana, I'd like to share with you, like in Brazil, as you said, María Inés, you're giving us a broad view, but I can share with you the experience in Brazil, which is very positive of public administration lately. I was an arbitrator in a case in which a public administration was a party, and I rendered an award, and it was not totally in favor of the public administration. The public administration lost part of the case. And in the end, you can't believe, in the end, after we have rendered the award, the arbitral tribunal received a joint email from the private party and the public attorney saying, thank you very much for the great award you have rendered. we have reached an agreement. We have complied spontaneously to the award. So thank you very much for the great proceedings that we had. So the good faith, not only regarding the force of the arbitration clause, but also when you lose a part and say, you know, it was fair. It was fair, and thank you for having this due process, this. So it was such, I was so happy to see that, you know, so for me, it's an example how things are working well in Brazil with public administration. But Tatiana, please, you are our representative here to say.
Thank you, Eleanor. And it was good to know this. Nice. I love it, what you just said, because we are really trying here, trying very hard to try to be fair in everything. So when we have, of course, it's something, it's a conflict. So we have different positions. That's natural. But try to act all the time in good faith. Before the arbitration procedure, during the arbitration procedure, and after, as Eleanor said. So I think something we are, and we are trying, and I believe we are reaching. Actually, we don't use a judiciary system almost at all. You know, in the federal union, we have more challenges. It is not challenge. How do you speak this in English? When you want
yes.
to nullify the award?
Yes, it's challenge.
Yeah,
it's challenge the award. Yes.
Okay, and the challenge for the award are more from the private parties than from the public administration nowadays. So it's something we are very proud of, because we know if we have an arbitration that was fair, we are not using all the strategies to try to go to the courts. As I said, we want the relationship to be good back. So for us, it's very good to have an award and go on, you know, it's good. So I think it's, we have a different mindset nowadays. I know before there was a different mindset in public administration sometimes, but I believe now the mindset is going this way, and I think it's wonderful. I think it's very good. So it's something we are really proud of, and it was good to know what Eleanor just said. And just to address the question Eleanor has asked us, the positive and negative aspects, it's difficult to say this because it's something so complex when we are talking about this kind of procedure, you know. And I believe there is very positive points as the length we were saying about, and there are also the fact that the arbitrations could be experts in the issue we are discussing, and a lot of things. It's a procedure very good for complex discussions because it can be tailor-made, and the parties can do whatever is necessary to get to the as we were saying before, the material rights, the justice, the decision that's more fair to both. So I believe this is very good. The negative aspect, one of those is the cost, of course. It's obvious, it costs money, and sometimes you have to balance all this to in the equation to choose or not to choose arbitration procedures. If you are talking about a contract that is not a huge amount of money, or the question is not huge enough, maybe arbitration is not the best procedure, maybe, but you have to have this in mind when you're choosing. But one thing I believe we are dealing now, when we are talking about positive and negative factors, I'm talking in a way that, in an ideal way, but when we are dealing with concrete case, we now have a problem with the length in a part of our case. So we are dealing something that should be in a positive factor. Nowadays is a difficult we are dealing with. I don't believe it was transformed in a negative factor, because the length is lower than the courts, the state courts, of course. But it's something we want to address to now to make it better, maybe, to try alternatives to make it better. So we are having now some difficulties when we have these giant expert procedures inside arbitration procedures. So sometimes when we have the court experts and we have this procedure with court experts, sometimes it's taken too long. When I say too long, it's like 3 years just for expert analysis. So it's too long. Objectively, it's too long.
It's too long.
And sometimes there is, I believe, some issues in the moment when choosing the company. We are dealing with a lot of change in the indication, because when the first one comes, there is a conflict of interest, and then goes to the second and to the third. And I believe there was a procedure that we had 4 before being able to choose. And with each one of that, we had to have like a lot of faith. Nowadays, we are trying to reach an agreement between the parts and do the research before, but sometimes it takes too long when the parts are not so easy to have one opinion. It's to choose together. It's more difficult, of course, when you have an agreement between parties, it's easier. But sometimes we are dealing with that, and that's something we are now trying to address too. And I believe we are doing that, and we are talking about regulation after, and this is something I think we should have more steps on. But this is a difficult we are dealing now, but I don't believe this is something that puts a negative aspect or even will have arbitration out of our minds in public sector, but it's something that we have to adjust to be better, to be the way we thought it would be before, when we were thinking about it, when we were doing the regulation, when we were organizing the clause. So it's something we have to advance on.
Great. I had other questions for you both, but the audience have formulated a few questions. So as we have already discussed for 1 hour among us, so maybe if you're agreeing, I'm going to ask you a few questions that the audience have asked. And if the audience wants to ask more, please go ahead. I'm going to start by the ones who have already been formulated. So Delmiro Camargo asked, is there any research into how much the Institute has avoided judicialization? I don't know if there's any research that Chan is aware of.
Because it is an alternative from judiciary systems. So it does avoid judicialization on itself because it's an alternative way. But one thing I can say is that the last research we had, not just for public administration, but for all arbitrations in Brazil, is that less than 2%, I believe, of the awards were challenged in the judiciary system. So I think this is really good. This shows how this is respected by the parties in Brazil, and how the judiciary system avoid to enter in the merits of the award.
Well, taking into account the Latin America and a research, or quite recent research on the statute in Latin America, we can take the Latin American Conference report of 2020, and that report, the class report of 2020, shows that at that time, and taking into account a lot of or many countries from Latin America, the annulment, the awards that were annulled and declared void and null were 14% versus a remaining 86% that were in which the annulment request was rejected. So although it's not an optimum, is still a good result for a region as our region, because we know that in our region sometimes courts are not friendly towards arbitration, and mostly are not necessarily all of courts necessarily used to arbitration and the system and the basis of the system. On the other hand, I understand that such research and results were somehow impacted by the status of the Peru's annulments request and decisions on annulment, on awards annulment. And you know that in Peru, the use of arbitration is mandatory for a state for public procurement contracts. So you have there a volume of arbitration involving public administration that is huge, comparing other countries, and at least it's not strange to find out that courts may broaden, if you want, the review and the construction of the reason for annulment. Not because they would add another reason, but the way they may interpret and consider the application of those reasons to the case may be broadened than in a commercial or mere commercial dispute.
Great, thank you. Ricardo Rodil has asked about costs and length of arbitral proceedings and addressing, but Tatiana has already answered that question. The question was for Tatiana, but it was before she answered it, so I think it has answered. Another question about the research. Let me see. Gisane Dantas, is it possible arbitration in Brazil about tax? So it's a hard question for María Inés, but maybe you can share your experience, international experience also.
For tech issues?
Taxation.
Taxation. Taxation. Yeah. Okay.
Taxation.
Yeah. Well, no, not so much reason. I have dealt with some disputes involving taxation issues, but in commercial arbitration, because of the impact and the if you want, the burden and the distribution of the risk, more than a dispute against the state based on some taxation matter or discussion. And I think that it could be, but ultimately the kind of discussion, and this is a first thought, no? But the kind of discussion that could be bring to arbitration is that the distribution of risk and the distribution of burden. If you have, for instance, a contract with a state entity, and the state entity agree upon on an stability clause, concerning taxation and that burden. Well, that is a very common discussion and very common matter submitted or that could be involved in an arbitration. But the discussion is about the stability clause, which is the taxation stability. And at the end, it's a patrimonial, a monetary discussion, a dispute about well, who is in charge of or obliged to take and absorb that extra cost. Because it's a matter of price. It involving the matter involves the price, the final price, if you or cost involved, and who should face the extra cost involved in providing the service or the goods that are subject matter of the contract. So my answer is stability clauses, yes. There are disputes and are unusual, those disputes, when the stability clause is agreed upon and ultimately discussed, the scope or the validity or the application.
As for the taxation itself in Brazil, we don't have permission to do it. When I say we, I am saying about public administration. There are two law projects in the Senate discussing that, and it's something it has been discussed a lot. I believe in 2022, I believe, but I don't really know about any discussions now about that. I have a major concern. I'm not a specialist in taxation, so I cannot say about all the aspects that should be addressed there. But I have one main concern about how could this kind of arbitration system guarantee the equality between taxpayers. I'm really concerned about that. How could it be? And because this is one of the principles when we are talking about taxation itself. And so I have this main concern, but I really don't know the specificities of the project and of the discussion. And one thing I do know is that Portugal has one different system about tax arbitration. They have one system there with a chamber which is just for that, and it's just this chamber that is allowed to do it. So it has some kind of tax arbitration around the world. I know Portugal, for example, but in Brazil, there isn't nowadays.
Okay, so Ana, you have a question, so Ana can formulate directly your question to them. If you want, I can read it.
No, I have here. My question is actually to Tatiana. You're talking about the difficulties or the time that arbitration is taking because of expert examinations, tribunal appointed expert, which is kind of a Brazilian model for litigation. How, in your experience, is the public administration feeling or using more and more the party-appointed experts in arbitration without having the tribunal-appointed expert? How are they feeling about it in terms of moving away from a very, very traditional method of use here? And in your experience, are they using it?
Very good question, Ana. And we are thinking a lot about this. We are thinking about solutions, but one of them, of course, is this, because the problems we are facing with a tribunal-appointed expert should be at least less when we are talking about party-appointed ones. And we know in the Federal Union, we didn't use, we did use in the past once. We had one very good case we used that was Libra, the first arbitration procedure that is like a leading case in arbitration with public administration. It was part-appointed expert, and it was very good. The award was very good. The expert procedure was very good. But after that, I believe it's something that we are used to in Brazil, to have the expert appointed by the tribunal. So we tried this alternative for a long time. And now we are trying to think about alternatives, and using part-appointed experts is for sure one of them. We have some difficulties here because we are public administration. Sometimes it's more difficult to us for having a party-appointed expert that we could hire, because we have people inside who could do this job. And this is something it's kind of, we need to interpret the law to see in which case we could or not could hire this kind of personnel. So we have this. It's an issue, and that's why sometimes it was easier to use the tribunal appointed. But now is one of the alternatives we are thinking. Another thing we are thinking about is having a term of reference for this procedure, because sometimes we see that we have a lot of points that are very well marked in arbitration, but not so well marked in the experts procedure. It's more like loose, we believe. And I think it's good for the parties to sit and try to agree on a term of reference for this procedure, specific for this procedure, to give it the agility it needs and don't give much time for delays. And another thing we are thinking is how to avoid the problems sometimes we face with revelation procedures, conflict of interest in this scenario of experts appointed by the courts, because it has been demanding a long time, this phase, and we can see some experts are not used to the profound scrutiny public administration does, and we do. Actually, we have to, because sometimes we have our own regulation and we have to do sometimes a more profound scrutiny on them, and they are sometimes not used, and sometimes we have to come back with another question, then come back once again, and this takes time also. So we are thinking about how to maybe inside the term of reference address also this phase, to have more specific issues they should analyze and give us answer, and then more like less phases and less opportunities to go back and further, so we have more agility on that. So this is something we are thinking about, but for sure part-appointed experts are something we are trying to do, and we are trying just to surpass the obstacles we have now and try to have alternatives. São Paulo, for example, they have a contract for this kind of thing. They could hire some people that are not from public administration to do this, to be technical assistants of São Paulo public lawyers. So this is something we can look and try to do just like that.
Would you like to comment, María Inés? I think like in international arbitration, party-appointed expert are much more common.
Yes,
appointed expert, right?
Yes, is the most used way to produce technical evidence. quite different from court proceedings and the usual way to produce the technical evidence at court proceedings in the civil court proceedings maybe. And I think that I never experienced that such a long time to produce technical evidence. 3 years is a lot. Maybe 1 year or almost 1 year in very complex, maybe infrastructure disputes could be complex, could happen, but 3 years for an infrastructure commercial dispute involving a public party, but commercial dispute is quite long. There are other issues involving this usual way. The party appointed experts. Sometimes you have two quite different opinions on the very same matters that lead to at least have some doubts about how impartial and the opinion is, because it's difficult to find such differences without any almost any common understanding in some of the matter stakes, technical matter stakes. But in any case, it happens. So that leads the tribunal to some no, I don't know if problems, but some need to see what the way to bridge those differences and find out the truth in a way, or an opinion or opinion that the tribunal can rely on. So there are different techniques, for that. The first one, the conference between the expert, the two expert party, or the party appointed expert, 2 or more. That could be something that is good, because sometimes between experts they avoid to be in conflict, because they know something is to explain this to lawyers, even to tribunal that are made up or made of by lawyers, but when they need to discuss between them, well, they know that they have an authority or someone with enough authority to rebut, or at least give another opinion. So the conference is something that in international arbitration we use. It's not something that is there in the procedural order 1 and never used. It's something that you may use, and is used when you have such differences between the two experts. Another technique, but it's hard for a tribunal to resort to that technique, is to, of course, select or propose the parties to, or even decided to appoint an official or a tribunal expert after the parties appointed experts have already provided their opinions. It's hard because it's another cost, more time. It's not the best solution, but sometimes you need that because the two opinions are irreconcilable. You can have something and have doubts on both because of that. So, but that is for me the last resort, because is in any case more time, more cost.
Interesting, the perspective.
That's
Different
the yes.
Yeah.
Yeah.
Okay, so I have one last question here from the audience that we have like 10 minutes to address and to wrap up. This is from Luiz Maia, my partner, who is also helping me with IASP here. Thank you, Luiz, very much for your help. And she posed a question. Tatiana mentioned that state attorneys are under scrutiny from inside the public administration, and that it can be tricky. In this context, how is the process of choosing an arbitrator?
Very good question. It was tricky in the beginning. I believe in the first place, we have, as all of public administration's choice, we have to motivate it. So I think the thing we have to do when choosing arbitration is to motivate why we choose that person. We discussed a lot how to deal with different contractual branches for this, but I believe nowadays we have our procurement and contractual law that states that arbitrators are chosen, are not. It's not. They are not hired. They are chosen. So this gives more comfort for the position. We already had that it's someone you choose because you can hire. You can, because when you hire someone, you have the right for the person you are hiring to do whatever you want to do, and it's not the case in the arbitration, of course. They are choose to act like a kind of judge. They are choosing to judge your case. They are choosing to analyze your case, and they will do or will not do what you want, and you have no control about that. So they are not hired. And this was the first question. And I think when you study arbitration, it's easy to answer. They are not hired for doing your service. But the second question is this kind of which are the criteria for that? That's something we pose for ourselves. You know, what the criteria we are going to use to choose an arbitrator. And this is something very tricky because sometimes, you know, choosing from one or another is not something so objective, but we have to motivate it. And this reasoning must be objective because we are public authorities. And we do this nowadays, we have a regulation for that. So in Federal Union, we have a regulation inside the General Attorney Office, which give us the criteria we have to use. There are some criteria that are binding for us, as, for example, the not having conflict of interest, the ones that are more broader, and also criteria we could observe or depending on the circumstance. For example, the language. For example, the arbitrator that was chosen by the other part. Sometimes, if you have a very complex conflict, if the other part has, for example, one person that specializes in civil law, you must wanted perhaps someone specializing in administrative law or something like that. So we have this in perspective when choosing. And also other criteria, we have the number of times one arbitration has been chosen is a criteria, not to put us on a situation of IBA, conflict of interest, and such things. So there are a lot of criteria, and these are the things we use when we are stating there. We choose Eleonora because she met this criteria, this criteria, this criteria, this criteria. And the same when we are dealing with, sometimes we have the list for the president that we can reject 1, 2, or so we do the same. We have like this inside information. We have that we have the criteria, and this criteria must nowadays, because there is an article on our procurement and contractual law that say that the criteria must be technical, objective, and transparent. These are the three things they must be. So that's why we have the regulation. Now we have criteria that are technical, they are objective, so one can see our list of criteria and can see they are objective, and they are transparent, so because they are on a regulation and everyone can know beforehand. If someone wants to be in an arbitrator in a procedure with public administration, they know beforehand which criteria we are used to use. We have to use, we are binding for that. So I think, but it was tricky in the beginning. Now I think it's really, really okay for us. But in the beginning, it was something tricky. Everything that's different, everything that goes outside the main roads you use it to be, it's quite tricky, but we are very comfort nowadays about the way we could regulate that and the way we are doing that.
See, María Inés, the public administration has their own arbitrator intelligence and just
Yes. Yeah, right. Well, and when artificial intelligence artificial intelligence will have here the power in the next future. So don't worry about those regulations or any or the differences between Jus Mundi and the state regulation, because ultimately in a couple of years maybe both of them will be used the artificial intelligence and the predictions in order to know, well, who can be the best option for the actual arbitration. That is my shock, but also a very sensitive issue to discuss in another webinar.
Yeah, we can have another one. It's a good suggestion to have another webinar on this topic. So, would you like to make any final comments, María Inés, Tatiana?
Tatiana, please. The state first.
Prerogatives.
Well, I have prerogatives here. That's good. I don't have an arbitration procedures, but I have here. Thank you, María Inés. Well, just to thank you all. It was a really pleasant opportunity to discuss this issue with you all, with the audience. I love it. There were a lot of questions for us. I love when this happens because I think it's so boring just to sit there and hear us. And now we had a lot of questions, a lot of debates, and it was really good to learn with María Inés. Thank you so much, María Inés, for your insights, for your explanations. It was really worth for me. So thank you, Leonora. Thank you, Ana. Thank you, Yaspi. And I am at your disposal anytime you want.
Well, thank you. Thank you, of course. Thank you, Yaspe and Tatiana. I recollect insights also from you and our discussion. I think that new challenges for state, either or both for state and private parties, are the efforts we need to do in order to prevent disputes and to jointly manage and handle those disputes eventually arising from the contracts in an efficient way. I think that, of course, this is a challenge for private parties, but it could be more challenging for the state, because the state has that bureaucracy and that need to preserve the state, but even the officials, from the questionings and maybe the pressure, and I mentioned here the pressure not in the bad way, but in the real way that they have. Nowadays, we are discussing in arbitration and the IDR proceedings and services, we are now discussing about solving problems, solving disputes more than arbitration. So, or another way, or court versus arbitration. I think that our main challenge is to handle disputes and preventing them. Sometimes, I don't know the case of Brazil, but in some countries and Latin American countries, this is also an issue because states are not allowed even to negotiate with flexibility or enough flexibility their disputes, and they need to submit their either to courts or arbitration and dispute that to the end. And that is costly always. And I think that I would suggest to start talking a bit more about that because we need to understand that neither for the state nor for the private companies, the conflicts are businesses. Businesses are businesses, public interests are public interests, and they are impaired when disputes arise and can be handled and solved quickly and costless and in an efficient way. So I at least I expect that, and of course, in the meantime, we will be discussing about the advantages of arbitrating disputes for states. Thank you very much.
Thank you very much. It was amazing. María Inés, I thought you were going to invite everyone to join ALArb. She's our president of ALArb. And it's very good to have this kind of, participate in this kind of forum, like ALArb, because we can have this broader perspective, this exchange, which I think it's completely relevant for arbitration. And, I think that once I heard that we are not in arbitration despite of our differences, but because of our differences. So I think it's, very useful for us to have this debate. So everybody's invited to come to ALArb and also to IASP. We are here with open arms for you, having you participating in these debates. And thank you very much again. Thank you, Ana. Thank you, Luisi, for the help. Thank you, Tatiana. Thank you, María Inés. Hope to see you soon. Thank everybody.
Thank you very much.
Bye.
Thank you. Bye.
Bye, everybody. Bye.
Bye.